Hi, my name is Kristen, and I'll be walking you through the process of preparing and presenting your assessment appeal of your property tax assessment at your county's Board of Equalization or Assessment Appeals Board. Since this subject is more involved than what can be shared in the short time we have together, I suggest you obtain a copy of Publication 30, Residential Property Assessment Appeals, and review it as well. More on where to get that publication later. This video has been prepared by the Taxpayers' Rights Advocate Office and the County Assessed Properties Division of State Board of Equalization, with assistance from all 58 elected county assessors and appeals boards. We hope this video will make the county assessment appeals process easier to understand and that it will help you present your best case. We have a lot to talk about, so let's get started. The first thing you need to know about your assessment appeal is to understand completely what you're appealing. This is done by spending some time reading all the information provided with your tax bill, tax notice, or supplemental assessment notice. If you have questions about your assessments, you should contact your assessor's office before you file an appeal. Tax bills can often be confusing, so don't be afraid to ask questions about your tax bill and assessment. The assessor's office will explain how the value is determined and can provide you with relevant appraisal information. Remember, assessment appeals have strict filing periods and deadlines. It's important to understand that the appeals board can only lower or raise a property's assessed value, remove a penalty assessment, or reverse a change in ownership or new construction reassessment. The appeals board, however, cannot reduce your property's assessed value simply because you're paying more taxes than your neighbor, remove penalties and interest for late payment of property taxes, reduce your taxes due to your inability to pay, grant or deny tax exemptions, change tax rates, extend filing periods, change the decision of another appeals board, or rehear an issue already ruled upon. But let's talk more about the events that trigger your right to appeal your property tax assessment and describe what you can appeal. If you believe the market value of your property has dropped below its assessed value, you can file a decline in value appeal for the current year. If your appeal is successful, you'll receive a temporary reduction in assessment, but only for the current year. Since a decline in value appeal only covers the assessment for the year in which you're filing, you must file a decline in value appeal for each year you disagree with the assessed value of your property, even though you may have an appeal pending for a prior year. Decline in value appeals must be filed during what is called the regular filing period. In most counties, the regular filing period is July 2nd through November 30th. However, in some counties, it's July 2nd through September 15th. Check with the clerk of the board to determine the regular filing period in your county. Remember, you must base your decline in value appeal on the market value of your property as of January 1st, the lien date of the year in which you're filing. Next, let's talk about appealing the base year value of your property. A new base year value is established for your property by the assessor when the ownership of the property changes or when new construction is completed. You can file an appeal if you believe the assessor incorrectly valued your property or if you believe there was no new construction or change in ownership that required reassessment. There are two filing deadlines to keep in mind for base year value appeals. You may file an appeal within 60 days of the mailing of the supplemental assessment notice you receive. In some counties, you also may file an appeal within 60 days following the mailing of the supplemental tax bill. Again, check with the clerk of the board if you're not sure which deadline applies in your county. You may also file a base year appeal during the regular filing period between July 2nd and November 30th, or in some counties between July 2nd and September 15th, in the year in which the new base year value is placed on the regular assessment roll, or within the following 3 years. Except under very rare circumstances, the base year value of your property cannot be changed after 4 years. That is, the year in which the value is placed on the roll and the 3 years following. Another type of appeal to discuss briefly is an appeal of a calamity reassessment. If the assessor has reassessed your property as a result of a natural disaster or other calamity and you don't agree with the value arrived at by your assessor, you can file an appeal within 6 months of the mailing of the notice of reassessment. Finally, you can file an appeal of an assessment resulting from an escape assessment or a roll change. Escape assessments and role changes are assessments relating to events that happened in prior years but were not discovered timely by the assessor. You may file an appeal of an assessed value resulting from these assessments and changes no later than 60 days after the date of the mailing of the assessment notice or tax bills in some counties. Okay, so now let's assume you understand your assessment and your appeal rights and have decided to challenge the assessment. You'll need to do this by filing the assessment appeal application, which is formally called an application for changed assessment. This application form is similar in all counties, but you must use the form for your county. If you use the wrong form, your application may be stalled or possibly not accepted as being filed in a timely manner. Call your local assessment appeals board or clerk of the Board of Supervisors at the number found on the information sent to you in your assessment notice or tax bill to obtain the proper application form. You now understand what specifically you're challenging and you have the proper form. The next step is to fill out the application for changed assessment form. There isn't time in this video for us to go through every step of filling out the application for changed assessment form. However, there are a few things you need to keep in mind. First, read the instructions on the back of the form very carefully. You don't want to have your appeal application rejected simply because of an error in filling out the form. Make sure you have the current official application form for the county where your property is located. Many counties make these forms available online, or contact the clerk's office to get the forms sent to you. Naturally, the clerk of the board will need your name, mailing address, and telephone number in box 1. However, if you plan to have a tax agent, attorney, or relative represent you, you should also include their information in box 2. If your agent is not a licensed California attorney, you must sign the agent's authorization under box 2, in addition to the signature required at the end of the form. It's very important that you correctly enter the assessor's parcel number and check off the type of property in box 3 so that the county can identify the property assessment that you're challenging. Enter the assessor's roll value of your property in column A of box 4. If you're unsure of the roll value of your property, contact the assessor's office. Also in box 4, it's vital that you enter your opinion of value in column B. Your application cannot be processed without this information. Box 5 is where you indicate the type of assessment you're appealing and the roll year involved. Write the roll year of your appeal, which is typically the fiscal year that begins on July 1 of the year in which you file your appeal. Check the type of assessment box that applies to your appeal. Check regular assessment for a decline in value appeal or for a change in ownership or new construction appeal that is filed after 60 days of the mailing of the supplemental assessment notice or supplemental tax bill. Check supplemental assessment for a change in ownership or new construction appeal that is filed within 60 days of the mailing of the supplemental assessment notice or supplemental tax bill. If you're appealing a roll change, escape assessment, or calamity reassessment, check that box. Box 6 is another very important part of the form. This is where you tell the appeals board the basis for your appeal, what it is exactly that you're challenging. If you're filing a decline in value appeal and challenging the roll value of your property as of January 1, the lien date of the current year, check box A. If you're filing a change in ownership appeal and you're claiming that there was no change in ownership eligible for reassessment, check option B1. If you're filing a change in ownership appeal in which you are challenging the value placed on your property by the assessor, check option B2 and fill in the date of the change in ownership. If you're filing a new construction appeal in which you're claiming that there was no new construction that should have caused a reassessment, check option C1. If you're filing a new construction appeal in which you're challenging the value placed on the new construction by the assessor, check option C2 and fill in the date the new construction was completed. If your property was reassessed because new construction had been completed as of the lien date, enter January 1 of the current year. If you're filing a calamity reassessment, check box D. Finally, be certain that you sign your application form. Understand that your application will be rejected if it's not properly signed. We'll talk talk about what information to gather in a moment, but first we need to talk about the timeliness of information and what is not admissible before the appeals board. An appeals board is only allowed to consider or rely on relevant evidence when making their decision about your case. Admissible evidence is evidence submitted at the hearing, either verbally or in writing. Written materials must be submitted at the actual hearing, not just attached to your application. In some counties, you're not permitted to submit any information along with your application. Also note that any conversations you had with the assessor will not be admitted for the board's consideration unless specifically discussed again at the hearing. If any information that you wish to submit at the hearing, such as an appraisal or a realtor's opinion of value, was prepared by another person, remember that the person who prepared it must attend the hearing so that the assessor and appeals board members can ask him or her questions about that information. Otherwise, only the raw data in that appraisal and none of the adjustments or conclusions can be admitted as evidence at the hearing. These same rules also apply to the assessor's evidence, except that the assessor's representative at the hearing may or may not be the same person who appraised your property. The person serving as a witness on behalf of the assessor's office can, however, be questioned by you and the appeals board regardless of whether or not he or she was the actual person responsible for your appraisal and assessment. This is because whoever testifies as to the value of your property on behalf of your assessor will be a Board of Equalization certified appraiser, and as such is fully capable of answering all pertinent questions about the evidence they have testified to. The method used for valuing your property will determine the type of information you'll need to gather. There are generally 3 methods for determining a property's value, but we'll discuss the one that's typically used to appraise residential property, the comparable sales approach. The backbone of your case is likely to be based on the value derived from the comparable sales approach, commonly referred to as the market approach. Let's look at this approach more closely. The market approach is based on the concept that your property's value is determined by the prices of other recently sold comparable properties in your area. We need to stop for a moment and talk about something referred to as the valuation date in relation to the value the assessor has put on the tax roll for your property. This is a date that will be particularly important when searching for comparable sales information to support your opinion of the value of your property. The valuation date can be defined as the date used by the assessor when establishing the assessed value of property. For example, when property changes ownership, the date of transfer is the valuation date. If you have new construction, the valuation date is the date the new construction was completed. If you're filing a decline in value appeal or an appeal of your property's base year value during the regular filing period, the valuation date is the lien date, January 1st of the current year. When appealing a calamity reassessment, use the date your property was damaged. When gathering comparable sales information, you need to look for sales of comparable properties that sold near in time to the valuation date for your property. This information can often be found by contacting local real estate agents and brokers, mortgage brokers, and real estate appraisers. Another very important source is your assessor's office. However, the data available at any of these sources must be verified to make sure it's accurate. It's strongly suggested that you drive by the properties you believe are the best indicators of the value of your property to see if the properties are comparable. But which properties are the best to use? Well, first, you must use a sale that was an arm's length, open market transaction. If not, the sale will not be admissible at your hearing as a comparable sale. An arm's length transaction means that the sale did not occur between individuals who knew each other or who are related. An open market transaction means that the property was advertised in the community as a property that was for sale. It's best to use properties that are most similar to your property in location, time of sale, and physical features. We'll discuss each of these items to adjust for when determining the value of your property. Location may be the most important item to adjust in your valuation. In fact, you've probably heard the real estate quip that the 3 key factors in your property's value are location, location, and location. You should therefore think seriously about the differences in location between your property and those that have sold recently. Generally, the closer to your property that the comparable property is located, the more likely it is that the same surrounding influences will affect its value. However, a nearby property may not always be comparable in location. A common example is two homes located very close to each other, but each served by a different school district. Also, one house may be located on a very busy intersection and the other on a quiet cul-de-sac. Remember, too, that just because two properties are described similarly on paper, you should take the time to drive by them so you can verify that they truly are comparable in quality, condition, and other respects. The closer the sale date of the comparable property is to your valuation date, the more likely it'll be a good indicator of the value of your property. Therefore, adjustments for differences between the time of sale and the valuation date of your property are critical if market prices are changing rapidly. If sale prices have declined since the comparable sale date and your valuation date, then you need to adjust the value downward to reflect the trend. You should adjust upward for time if the values are generally rising between those dates. The law prohibits the use of comparable sales that occurred more than 90 days after your valuation date for comparison purposes. Also, understand that listings of comparable properties are not considered as reliable indicators of value. You can go as far back in the past as necessary, but remember, closer in time is preferred and more relevant. With that said, let's discuss physical feature differences and generally how to adjust for them. Any physical feature differences between your property and the comparable sales should be considered. The differences in parcel size, zoning, or other structures like buildings and swimming pools should be noted. Once you adjust for these types of things, you need to look at the home specifically. Homes vary in size, shape, and quality. They vary in condition and room count. All of these differences need to be considered, but much of this work has already been done for you by your assessor's office. This is a good place to discuss where to find the information about your home and the comparable properties. Your assessor's office has the construction detail for all buildings in your county. This information is found on what's called the property's building record. It's this record we suggest you get for your property. Contact your assessor to obtain the building record for your property. There may be a small fee for this, and you may not be able to order it over the phone. If you go to your assessor's office to get the building record, you can have them explain specifically what's on that record. Since the same information is useful for the comparable properties, you should try to get as much of this relevant information as you can for those properties as well. Your assessor will generally make the property database information accessible to you, but you won't be given access to the physical records of comparable properties that you don't own without that owner's written permission. Remember, there's a worksheet on page 11 of publication 30 that will help you organize the information for comparable properties. I need to briefly mention the process of exchanging information with your assessor during the appeal process. An exchange of information is a formal process that can be initiated by you or your assessor. This exchange of information process is important because if either of you initiates the process, then only the information that has been exchanged can be used at the appeal hearing. This process is intended to provide you with information to understand your assessor's valuation method and the factual information they're relying on in their appraisal. By knowing this, you can be prepared to challenge that method or information. The same is true for your assessor, since during a formal exchange process, you must provide your information to your assessor prior to the hearing. On residential assessment appeals, these formal exchanges are not used very often. These exchanges have strict filing deadlines for initiating and responding, so check with the clerk of your appeals board and see publication 30 for more information. After the clerk of the board processes your properly completed application, you and your agent, if you have one, will receive a mailed notice of your hearing at least 45 days in advance. You're now ready to attend your hearing and present your case. An assessment appeal hearing is not as formal as a proceeding in a court of law. The hearing may be held before an appeals board panel or a hearing officer in a conference room or in a larger meeting room. The rules for the hearing are the same regardless of the type of room they're held in and will be explained to you prior to the start of your hearing. Many counties have adopted local rules of procedure governing the assessment appeals process. Prior to your hearing, you should ask the clerk of the appeals board for a copy. If you don't understand a procedural rule or issue, please ask the clerk for clarification. And if you need a clarification during the hearing, don't hesitate to ask the appeals board for clarification as well. They'll gladly explain the process so that you know what to do. The appeals board or hearing officer will be seated so that information being presented by you and the assessor's representative can be seen and heard. At a hearing before the appeals board, there will be a clerk present, and a recording device may be used to record the hearing. Depending on the size of the room, a microphone may be needed. The hearings are open to the public, so there may be other people who are present and listening to your case. You may wish to attend a hearing prior to yours to see how they're conducted. Contact the appeals board to find out when hearings are scheduled. When asked to present your testimony, relax and speak clearly and slowly. And remember, you're not expected to have great public speaking skills. Just be yourself, be polite and respectful. Although your county may not have a strict rule on how long your presentation can last, concise and appropriate information is more likely to be heard and understood. In most residential property appeals, the assessor's representative will present the case first. For assessment appeals of owner-occupied residential properties, if you have supplied all information to your assessor as required by law, the assessor will be required to present the case first to prove that the enrolled value is correct. If sufficient evidence is not presented to show that the assessor has met that burden of proving the value on the roll, then you will not need to present any evidence to win your appeal. It is rare, however, that an assessor does not meet the burden of proof, so be prepared to present your case. When presenting your case, it is your responsibility to present independent evidence that you have produced to show that the value that the assessor has suggested is incorrect. Simply criticizing the assessor's case is not enough. After each side makes its presentation, the appeals board gives the other side a chance to ask questions about that party's evidence and testimony. When it's your turn for this, you should ask questions to show why you think the assessor's information is less reliable than your information. After questioning is completed by one side, the board members or hearing officer may then also ask some questions of the witness who testified. The same will be true when the other side has completed its questions. After that, each side will normally be invited to summarize their case if they wish. It isn't difficult to do this successfully. More often than not, and especially for single-family residential properties, the best summaries are short and simple. When it's your turn, remember to emphasize what you felt were the weak points of the assessor's case and the strong points of your own. When the presentations are completed, the appeals board will either make a decision on your appeal immediately or take the matter under consideration and render a decision at a later date. If they take the appeal under consideration, they'll provide you with a written decision within a specified length of time. You'll be told when to expect the decision, but if not, just ask. The appeals board can agree with your value, your assessor's value, or another value that they think is more appropriate based on the evidence presented. This is the value that will be enrolled on the tax roll for your property. However, this doesn't end your appeal rights. If you disagree with the appeals board's value, your next step in challenging that value is to claim a refund from the county for the amount of tax you believe has been overpaid. You must file a claim for refund with your county board of supervisors unless you indicated on your assessment appeal application form that your application also constituted a claim for refund. Please refer to Publication 30 on this point. The county supervisors will decide whether your claim is valid. If the claim is not considered valid, your final option for challenging the assessment is in Superior Court. If you're prepared to take your case as far as Superior Court, you should be sure to ask for written findings of fact before your appeals hearing begins. You can check with the clerk of the board to find out how to get written findings of fact for your hearing. There is a charge, so be sure to ask the clerk for an explanation and estimate of these charges. These further appeal rights are explained in much more detail in Publication 30. That basically explains what you can expect in the assessment appeals process of your residential property. And remember, there's much more to an assessment appeal than we could cover in the short amount of time we've had together. So be sure to get Publication 30, Residential Property Assessment Appeals. Publication 30 is available from your local assessment appeals board or your assessor's office and is also available on the State Board of Equalization website at www.boe.ca.gov. Click on Property Taxes and then on Publications. Publication 30 will refer you to more sources of information about manuals, law guides, and offices that can help you obtain the appeal information you'll need to present the best case possible. If you do what's suggested in this video and what's discussed in Publication 30, you'll have the best chance for being successful in your assessment appeal. Good luck, and thanks for taking the time to walk through the appeals process with me.